Welcome back to Lost Dash Channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. A few months ago, I published a series of videos dealing with vehicular searches without a warrant. For those of you that watch my channel, you already know that the Fourth Amendment protects you against unreasonable searches and seizures, meaning that the officers generally need to have a warrant before they can search your vehicle. But sometimes exceptions apply, and those series of videos dealt with those exceptions. So I encourage you to go back and watch those videos so you can have a general idea of how these searches work. Now, today we're going to revisit a topic, namely prolonged stops under Rodriguez. This is the Supreme Court case that said that certain searches will be deemed a violation of Fourth Amendment if the officer prolonged or added more time than necessary when issuing a traffic citation. Today we're going to look at the 10th Circuit case that deals with prolonged stops. In this video, we're discussing United States versus Frazier, which is a 10th Circuit case that was published just a few weeks ago, and it deals with prolonged stops. So here's what happened. Mr. Frazier was traveling on I-15 North on November 12, 2019, and according to the officer, he was going a little fast. So the officer began to follow Mr. Frazier, and in the next few miles, he noticed that Mr. Frazier also failed to signal for more than 2 seconds twice while he was changing lanes. Now, this is a violation of Utah traffic code. So because of that, the officer pulled over Mr. Frazier. At 9:07, the trooper exited his own vehicle, his cruiser. As he approached Mr. Frazier's vehicle, he noticed a duffel bag on the back seat. To him, that was suspicious because according to the officer, individuals often carry narcotics in duffel bags. Mr. Frazier rolled down his window about 4 inches. At that point, the trooper asked Mr. Frazier to roll the window a little bit more. So he complied, and Mr. Frazier rolled down the window another 2 inches. At that point, the trooper also noticed an air freshener in a bottle in the middle console inside the vehicle. Now, according to the officer, individuals who carry illegal aliens or narcotics often use air fresheners to make sure that the vehicle does not smell like narcotics. Now, at this point, Mr. Frazier handed over his driver's license. The officer noticed that the driver's license was from Iowa, but in the wallet, there was another driver license, another ID, and that ID was from Missouri. Now, the officer was suspicious, so he asked Mr. Frazier how come he has 2 forms of identification from 2 different states. So Mr. Frazier explained that he often goes to both states, their neighboring states, and that the information on both IDs match each other. So when the officer looked at these 2 identifications, he noticed that it was in fact matching, and so there was no longer any suspicion that there was something criminal going on with his driver's licenses. Both of them were legal and validly issued. At this point, Frazier could not locate his car rental agreement. So he got on the phone with the rental company to try to get it, because there was some conversation between him and the officer whether the rental agreement was at some point emailed to Mr. Frazier. At 9:09, the officer began to ask a number of questions. He asked Mr. Frazier where he was coming from. Mr. Frazier explained that he was traveling from California, where he visited his sisters. Then there were more conversations about the rental agreement, and then the officer again asked for how long was Mr. Frazier staying at the sisters before he began traveling north. Instead of answering that question, Mr. Frazier said, "How come you're asking me these questions?" And the officer explained to him that he often, if not always, asks these questions. So Mr. Frazier refused to answer. Instead, Mr. Frazier had the rental car company send him the rental agreement by email over the phone. And he also explained to the officer that he had this vehicle for months because he was previously in a wreck and his own vehicle was damaged. At 9:11, the trooper returned to his own cruiser, and at this point, we're talking about roughly 4 minutes later, he still did not begin the standard procedures of issuing a ticket. Instead, he began to contact a canine handler. He messaged him by instant message system that they have in the vehicle. When the canine handler did not answer, he then radio called him. This other officer still didn't answer. And so only then he began to start issuing the citation. And at this point, it's 9:14 in the morning. Then at 9:18, the officer asked the dispatch to run criminal history. Okay, there was a couple of videos that I've published a few weeks ago that dealt with running criminal history during traffic stops. I will put one of those videos above, and of course I encourage you to click on the link and watch it. At 9:22, the trooper went on the phone with the rental company, and the rental company corroborated that Mr. Frazier in fact did have the vehicle for roughly a month because his own vehicle was damaged in a wreck. So the rental company did explain to the officer that Mr. Frazier was in fact an authorized driver of this particular vehicle. Between 9:24 and 9:26 in the morning, the canine handler finally arrived, and the dog sniff occurred at the vehicle. Then there was a search inside the vehicle because the canine did alert to the handler that potentially there were narcotics in the vehicle. They searched it and they found fentanyl pills. So as you can see, these cases with prolonged stops are factually heavy. So we have to explain exactly what happened by minutes. So the stop started at 9:07 and they found the pills roughly at 9:26. So we're talking about roughly a 20-minute stop. But remember, the timing itself is not important. I've published the case Rodriguez on my website before. I've explained it many times on this channel, and I still get comments in my videos saying whether 15 minutes or 20 minutes or 30 minutes becomes unreasonable, but that's not the standard. Under Rodriguez versus United States, and here's the citation from 2015, the Supreme Court tells us that the seizure of the passenger or other passengers in the vehicle ends when the tasks tied to the traffic infraction are or reasonably should have been completed. Meaning that when the driver and the passengers get pulled over for a traffic citation, the officer has to start issuing that citation. He has to do those standard procedures. And if he doesn't, he's prolonging the stop. There are three factors that we look at. Whether the officer diverts the investigation into a general criminal investigation, meaning that instead of issuing the citation, we're now in the general criminal investigation of something else. Whether he prolongs or adds time to issuing the citation. And finally, whether that detour on unrelated issues is supported by reasonable suspicion. So it is not exactly the timing that matters, but whether there's reasonable suspicion or prolonging of the traffic seizure. Now, in this case, we have to look back at the facts and see whether the stop was in fact prolonged, because the government argues that the officer had reasonable suspicion that the crime occurred And so that's why he's prolonging the stop. If the officers have reasonable suspicion ahead of time, then of course they can detain the driver and passengers of the vehicle. In this situation, we're looking at a number of factors. The government argues that the officer right away noticed that there was a duffel bag in the back seat of the vehicle. And according to the officer, people often carry narcotics in duffel bags inside the vehicle. But the 10th Circuit doesn't buy it. The 10th Circuit says that having a duffel bag is merely evidence of travel, because innocent people carry their clothing and other innocent items in the duffel bags. It's not necessarily used for criminal conduct. In terms of the window being rolled down only 4 inches and then a little bit more, and having air freshener, again, the officer explained on the stand that this was common technique by narcotic smugglers. But the 10th Circuit again doesn't buy it. The officer never testified that he smelled any contraband or any deodorizer. But why didn't he smell it? Well, because that air freshener was not one that you were hanging in your car. It was inside a bottle. And so it wasn't making any smells in the car, and the officer never testifies about the smell of the contraband. And in terms of the window being rolled down just a little bit, well, we're talking about Utah, and it's 44 degrees outside. An individual inside the car might not want to roll down the window all the way down when it's that cold outside. But clearly there was enough space in the window opening for the officer to see inside the vehicle, to have conversation with Mr. Frazier, and of course even pass on documents like driver's licenses. Next, the questions. The officer testifies that because Mr. Frazier did not want to answer all of the troopers' questions, that was suspicious, and there was reasonable suspicion that crime has occurred. But the 10th Circuit says that a refusal to answer police questions cannot form reasonable suspicion. Of course, Mr. Frazier doesn't have to answer unrelated questions. And in fact, he might not need to answer any questions during the traffic citation and investigation. Then the fact with the 2 IDs. Well, the government doesn't even argue at this point that there's anything illegal about having 2 driver's licenses. They simply tell the 10th Circuit that it is an odd fact. Well, of course, odd facts are just like a hunch, and that's not reasonable suspicion. A hunch by the officer is never reasonable suspicion that a crime has occurred. And finally, the rental agreement. Just because Mr. Frazier was driving a rental vehicle doesn't mean that he was committing a crime. And because he didn't have it on him, there might be reasons for the officer to prolong the stop to investigate whether Mr. Frazier is in fact an authorized driver of this vehicle. But that's not what the officer was doing. He wasn't prolonging the stop to figure out whether Mr. Frazier was in fact an authorized driver in the agreement. What he was doing is calling the canine unit and trying to do a drug canine search. So at the end of the day, the 10th Circuit says that all of these factors do not prove reasonable suspicion. And because there's no reasonable suspicion, the officer did in fact prolong the stop. So the 10th Circuit says that this is in fact a Fourth Amendment violation, and the fruits of the search should have been suppressed at the district court level. If you enjoyed this video, please click like, subscribe, hit that bell notification button, so next time I post, you'll be first to know. Thanks for watching.